The first hearing scheduled by the tribunal is a brief one-day hearing to decide the issue of jurisdiction. It has granted Respondents' Counsel 3 hours in the morning and Claimants' Counsel 3 hours after lunch to make their respective arguments. Thereafter, the arbitrators will have about 2 hours for their own internal deliberations. The hearing takes place at Maxwell Chambers, Singapore's premier arbitration facility. Let's join them there to get a taste of this stage of the process and perhaps some of the famous coffee there.
Presiding Arbitrator, sir, members of the Tribunal, a very good morning. We represent the respondent, Electro-ACE Incorporated, in this arbitration, and we will address you this morning on the issue of jurisdiction. The respondent challenges the jurisdiction of this Honourable Tribunal to decide this dispute on the ground that the contract between the parties is tainted by illegality, as it was secured through corrupt payments made by a middleman. In the course of my argument, I will establish the legal position and provide factual proof that the claimant engaged a middleman who bribed a former Power Minister of Eurasia to strongly recommend that Electro-ACE award the power plant contract to Asianix. Let us first consider the legal position. Corruption in the securing of international contracts has long been a blight affecting the commercial world. And what are the symptoms? The loss of an even playing field. It gives undue advantages to some, disadvantages others. Great economic cost to the nation involved if the contract is one of national importance. A loss of ease in doing business and a loss of goodwill within the business world. Now, with this in mind, I'll first establish that the illegality of bribing public officials is considered part of transnational public policy. Secondly, I will contend that as arbitration cannot endorse a violation of transnational public policy, this tribunal cannot be permitted to decide the merits of this dispute. The illegality of bribing public officials is a well-documented rule of transnational public policy. This has been recognized in a number of international conventions, including the UN Convention Against Corruption in Articles 15 to 19, as well as the OECD Convention on combating bribery of foreign public officials in international business transactions, Article 1. A number of court decisions and arbitral awards support this view as well, such as ICC Case 8891 of 1998, Wiener Hotels in Egypt, an ICSID decision, and X Limited and YBV, which are all contained in our bundle of authorities. Eurasian law, too, joins the world in declaring bribery of public officials illegal, and the punishment for such conduct in Eurasia is stringent. Thus, it is clear, by international consensus, bribery and corruption are to be condemned as morally unacceptable and economically disastrous. Now, sirs, let us consider what might happen when arbitration enters the picture. The use of arbitration agreements to resolve corruption-tainted disputes actually furthers criminal schemes and violates public policy. Although rare, when such disputes do arise, the arbitration agreement would be unenforceable. International arbitration must not be used as a tool to further unlawful contracts. And sirs, this conviction of principle was most famously expressed by Judge Lagergren in 1961 in ICC Case 1110. He declined jurisdiction over an agent's claim for commission because he had been retained to bribe Argentinian government officials to secure a government contract. And in his words, parties who ally themselves in an enterprise of the present nature must realize that they have forfeited any right to ask for assistance of the machinery of justice. national courts, or arbitral tribunals in settling their disputes. In another case that is factually similar to the present one, namely World Duty Free Company Limited and the Republic of Kenya, an ICSID tribunal dismissed the claimant's claims upon discovering that the contract under which the claims were brought was procured pursuant to a cash bribe to the then Kenyan head of state. The effect of such illegal acts upon arbitration agreements is actually best summed up by the ICSID Tribunal's decision in Inchesa and El Salvador. In this case, the tribunal noted that it was not possible to recognize the existence of rights arising from illegal acts, because to do so would, as a principle of transnational public policy, violate respect for the law. Members of the tribunal, we offer ample factual evidence to establish that the claimant engaged a middleman who was notorious for unethical lobbying and corrupt practices in Eurasia, and directed him to do, and I quote, whatever is required to secure the contract with the respondent. It is therefore hardly surprising that under this liberal mandate, he proceeded to bribe a person no less than the incumbent power minister of Eurasia, and through him influenced the respondent's choice of the claimant's services. The exhibits provided in our bundle of documents show a letter from the power minister to the respondent directing the respondent to utilize the claimant's services, newspaper reports raising allegations against the power minister for receiving kickbacks, and investigative reports into the activities of the middleman that highlight this financial transaction as being suspicious. Members of the tribunal, it's therefore clearly established that the contract was, from its very inception, tainted by corruption. For this reason, it simply cannot form the basis of a claim to be adjudicated by an arbitral tribunal. The claimant, through its unjust acts, has forfeited its right to ask for assistance of the machinery of justice to settle its disputes. Sirs, unless there's any other matter on which I can be of assistance, that is all. Thank you.
Thank you. We will now invite counsel for the claimant to deliver her responsive submission.